Good afternoon, Alan. My name is KUAN YEW XUAN. My role here is to explain the following issues that you are currently facing. I'll explain how the law protects you as the owner of Pine View Cottage and what you need to know about Tina and David's claim. The Land Registration Act 2002 is designed to provide certainty and security to registered proprietors like you through three main principles. The mirror principle ensures that a land title registration accurately reflects all important details such as ownership, limitation, and rights of others over the property. Tina's lease, if over 7 years, should have been registered, but if under 7 years and she has actual occupation, it could be an overriding interest. As a purchaser, you should have been aware of her presence during inspections. For example, in the case William and James Bank and Boland, 1981, the House of Lords ruled that registered equitable interests do not bind a purchaser if not recorded in the register. The curtain principle allows certain equitable interests to be hidden from a purchaser's view without affecting the validity of the transaction if the registration reflects the true title. An option to purchase is a registerable interest that must be entered in the charges register to bind third parties. If David's option is not registered, it has no legal effect against you as a bona fide purchaser under Section 29 of the LRA 2002 unless it is an overriding interest. In the case of Chuck, Harry, and Yazoo 2012, the Court of Appeal ruled that a purchaser is not required to investigate unregistered equitable interest. Third, the insurance principle guarantees compensation for any loss incurred due to reliance on the land registry if the registration fails to disclose relevant interests. If Tina's lease is overridden or David challenges title due to fraud or mistake, you can claim indemnity for any loss in property value, income, or potential. How-come indemnity depends on proper due diligence. For example, in the case of Abbey National Building Society and KUAN, 1991, the House of Lords confirmed that the insurance principle allows compensation for loss caused by land registry errors and omissions, applying similarly to Tina's lease or David option. Now we proceed to the LRA 2002, Protection for Registered Land. Since your ownership of Pine View Cottage is registered under the Land Registry, you are legally recognized as a rightful owner under Section 58 of the LRA 2002. According to the Section 103 LRA 2002, if the register is incomplete or inaccurate and you suffer financial loss as a result, you may be entitled to indemnity compensation. In the case of Swift First Ltd and Chef Land Register 2015, the court granted indemnity under Section 103 when rectification of the register caused financial loss to an innocent lender. Even with the registration, certain rights or interests may still affect property. Overriding interests not recorded on the register can bind third-party purchasers. This includes the rights of occupier, government by Schedule 3 of registered land and Schedule 1 for unregistered land under the LRA 2002. You may look into a journal article, Overriding Interest, Registration Gaps and Actual Occupation, written by P.G. McHigh. To begin with, could Tina's override your title under Schedule 3, Paragraph 2 of the LRA 2002? An interest that overrides a registered title may include short leases, where leases are for less than 7 years, while Tina's lease equals to 7 years, which is not exceeding 7 years. It qualifies as a short lease under Schedule 3 and thus may be overriding interest. There are few elements to satisfy Tina's lease to bind your title. Firstly, Tina must have a valid interest in the land, which she does if she has a lease agreement with Charles that is not subject to the Settled Land Act 1925. The case Webb and Mount 1966 supports the idea that. Secondly, actual occupation is a key requirement for Tina to assert an overriding interest. Since Tina has lived in Pine Cottage for 2 years, she clearly satisfied this condition. The case Williams and Gleams Bank and Boland 1981 establishes that actual occupation is determined by the specific facts of the case, rather than being a matter of law. Tina's 2-year stay would likely qualify as actual occupation. Additionally, the case Hodgson and Marks 1971 supports the idea that actual occupation involve more than physical presence, and Tina's long-term stay fulfills this requirement. Turning to David's option to purchase, he asserts that he entered into an agreement with Charles 3 years ago, granting him an option to buy Pine View Cottage. However, this option is not recorded on the land registry and does not meet the requirements for registration under the LRA 2002. And for David's option to bind you as the new owner, it will need to qualify as an overriding interest under Schedule 3 of the LRA 2002. However, an option to purchase typically does not qualify as an overriding interest or another legal rights visible to a potential buyer. Another issue is whether Tina's alleged lease can bind you as the new owner of Pineview Cottage. In the case of Street and Mountford 1988, the case implemented 3 crucial elements. Exclusive possession. In a scenario, Tina claims to have been in the room on the 2nd floor of Pineview Cottage for the past 2 years under a lease agreement with Charles. If she has been living in the property and has exclusive possession of that room, this suggests that she might have a lease. Secondly, the time period. In your case, Tina argues that she has a lease agreement with Charles for another 5 years. If this lease is in writing or there is evidence of such an agreement, however, if no written evidence of this term exists, you could challenge the validity of the lease, but this term could lead to difficulties in forcing this element of a lease. Thirdly, rent. In your circumstances, if Tina has been paying rent to Charles for the room she occupies, this would suggest that the arrangement is a lease. You could inquire about rent payments and any other indications that Tina's occupation is in exchange for rent. Subsequently, protection of a lease for registered land differentiates into legal lease or in an equitable lease. For a lease to be legal, it must meet necessary formalities such as being in writing, signed by both parties, and having a definite term. An equitable lease arises when the formal legal requirements for creating a legal base are not fully satisfied, but there is a binding agreement that equity recognizes as enforceable. For instance, in the case of Falls and Stays 1882, the Court of Appeal ruled that when there is a valid contract for a lease but no exit is executed, equity will treat the lease as if it had been created. One potential defense you could raise is that Tina's occupation of the 2nd floor was not obvious or sufficiently visible to you as the new owner. For an equitable lease to bind a new owner, the occupation must be apparent or obvious enough that the new owner could have discovered it prior to purchase. For example, in the case of Williams and Gleam's Bank and Boland 1981, the House of Lords held that for an overriding interest to bind a purchaser, the occupation must be apparent and visible to the purchaser. Additionally, if there was no formal lease written agreement or clear evidence of tenancy, you could argue that Tina's lease is invalid and does not meet necessary legal requirements to bind you. This example here is City of London BS and Flag 1988. The House of Lords held that unregistered equitable interests such as unregistered lease may not bind a subsequent purchaser unless it is protected by registration or qualifies as an overriding interest. There are a few actions you may take. First, you should first try to obtain a copy of the alleged lease agreement between Tina and Charles, as any written documentation or correspondence supporting her claim could be crucial in determining whether her rights are equitable. You can challenge the validity of the lease by arguing that it does not meet the statutory requirements for a legal lease and was not registered in the land registry, meaning it may not be binding on you as the new owner. You should also investigate whether Tina's occupation was visible and whether any signs of her tenancy. Lastly, if Tina is attempting to assert an equitable lease, you could argue that the requirements for an equitable lease, such as written evidence and a clear intention to create a lease were not met, or that rights were not sufficiently for you to have been aware of them. The last issue is whether David's option to purchase will affect your position as the new owner of the property. Option to purchase is an estate contract that under equitable interest, it is governed by Section 1 subsection 3 of the Land of Property Act 1925 LPA 1925. This section provides that all other estates, interests, and charges in or overland tail effects as equitable interest. There are few conditions to satisfy option to purchase under the Land Charges Act 1972 LCA 1972. An option to purchase constitutes an equitable interest in land and must be registered under a Class C IV land charge against the name of the landowner, in your case, which is held to be enforceable against a subsequent purchaser. If the option is registered, it will bind subsequent purchasers as per Section 4, Subsection 5 of the LCA 1972. In your scenario, since you could not find any record of the option of David to purchase at the Land Registry or Land Charges Register, it appears that David's option was not registered. A case example to support your scenario: in Midland Bank Trust Core and Green 1981, the court held that an unregistered option to purchase, which constitutes an equitable interest, is void against a purchaser for value of the legal estate under Section 4, Subsection 6 of the Land Charges Act 1972. Besides, in the case of Diligent Finance Corporation and Allen 1972, the court held that an unregistered equitable interest such as a second mortgage was void against the subsequent purchaser for value under Section 4, Subsection 6 of the Land Charges Act 1972. Even if the purchaser was aware of it, for David's option to affect your ownership, it must have been protected through registration or as an overriding interest. An option to purchase can be registered as a notice under Section 32 LRA 2002, ensuring its invisibility in the land registry. Alternative, it may bind a purchaser as an overriding interest under Schedule 3, Paragraph 2 LRA 2002, provided David was in actual occupation of the property at the time of your purchase. Since you discovered no record of David's option in the land registry, indicating that it had not been registered. Additionally, consequently, your registration as the new owner is safeguarded by the principle of indefeasible of title under Section 58 of the Land Registration Act 2002, which protects registered proprietors from unregistered and non-overriding interests. Since David's option was neither registered nor recognized as an overriding interest, you will likely acquire the property free from this claim. For example, in the case of Bank and Carrick 1996 highlighted that unregistered equitable interest is registered land cannot bind a purchaser for value if they are not overriding or protected on the register. The position of a purchaser is under Section 28 LRA 2002. A transferee without value, for example, someone who does not pay for the property, will be bound by all pre-existing rights. Whether those rights are entered on the register or not, it contrasts under Section 29 LRA 2002. For example, in the case of Halifax and Curry Poppet 2008, the court held that whether a transfer is for value is a question of fact, not form, and that a purchaser for value is only bound by registered right or overriding interest. The doctrine of notice is a principle in property law that determines whether a purchaser or transferee of lands is bound by prior equitable interests based on their knowledge of those interests. The doctrine of notice applies differently pre-1925 and post-1922. During pre-1925, the doctrine of notice was crucial in determining whether equitable interests were enforceable against a bona fide purchaser for the value of the legal estate. During post-1925, the doctrine of notice no longer applied to purchasers of registered land under Land Registration Act 2002. A bona fide purchaser for the value of the legal estate is only bound by registered interest or overriding interest under Schedule 3 of the LRA 2002, such as rights of actual occupation. Under the LCA 1972, unregistered interest must be registered to be enforceable against a purchaser for value. If an unregistered interest, such as an option to purchase, is not registered as a Class C IV land charge, it will be void against a bona fide purchaser for value under Section 4, Subsection 6 of the LCA 1972. In your scenario, since David's option to purchase was not registered and does not qualify as an overriding interest under Schedule 3, Paragraph 2 of the LRA 2002, you as a bona fide purchaser for the value of the legal estate is not bound by it. For instance, in the case of Shami and Land Securities 2013, the Court of Appeal clarified that the doctrine of notice does not apply to a purchaser of registered land under the Land Registration Act 2002. In this case, the court ruled that a purchaser of a registered land who had no notice of an unregistered equitable interest was not bound by it. The unregistered interest was not protected by the register, nor did it qualify as an overriding interest under Schedule 3 of the LRA 2002, so it did not affect the purchaser's title. In conclusion, the Land Registration Act 2002 protects you as the registered owner of Pine View Cottage. Tina's list might bind you. David's option to purchase won't affect you since it wasn't registered. If you need further assistance with removing Tina or responding to David, feel free to contact me and I will guide you through the next steps. Thank you.